you have increasingly a failing state. But a failing state does not mean that you have a failing society. On the contrary, you might have within that society, within the populace of the state, you might have a wide variety of localized communities, cultural communities, and so on, which are simply filling the void left by the retreating, by the failing state.
Good morning, Afghanistan. My name is Donald, and welcome to WorldView. At WorldView, we explore everyone's perspectives on all things that can broaden our worldview. Today, we're talking with Professor Koos Malan. The professor has been a state prosecutor, a magistrate, and he is currently a professor at the University of Pretoria and a constitutional jurist. He has authored 2 books, There is No Supreme Constitution, a critique of statist-individualist constitutionalism, and Politiocracy, a critique of the coercive logic of the territorial state and ideas around a response to it. Professor, good morning and welcome to you on this freezing Cape Day.
Good morning, Donald. Good to speak with you. I'm speaking with you from a very pleasant, sunny spring Pretoria. Although it's the 30th of August, it's spring here.
Now you're just bragging. But Professor, can you tell us your book, There is No Supreme Constitution? What is the theory you put forward in this book?
In a sense, the theory is already encapsulated in the very title of the book, There is No Supreme Constitution. Let's leave aside for the moment the rest of the title. But there is no Supreme Constitution, as I've said, summarizes, encapsulates what is argued in the book. In the first instance, normally, in terms of our constitutional mythology, our constitutional beliefs, one can even say our constitutional theology or religion, we believe that the Constitution is supreme and that everything that is somehow incompatible with the written Constitution is invalid and of no consequence. And secondly, it is also believed, in line with that, in step with that, that there could be no eventuality, either legislation, any state action, or any political events that could somehow disrupt the Constitution. In other words, it is believed that the Constitution really is the steering agent that determines in the finest detail how a constitutional order, how society functions, and I'm basically questioning that. I'm saying no, precisely the opposite actually obtains, and that is that the Constitution is consistently being constituted in the sense that potent political forces, potent economic forces are consistently making and remaking the Constitution. In other words, what it boils down to, that in order to establish what the Constitution actually entails, one should not stick to the wording of the Constitution as if that contains a reliable description of what the Constitution entails. No, one should actually call it political work, call it socio-political work. Look at the actual happenings, the actual events, how it unfolds within a society, and that will give a more proper, more reliable description of what the Constitution really, in the actual sense, consists of. In other words, just lastly, as far as this answer is concerned, in other words, one can basically distinguish between 2 constitutions. The one is the Constitution with all the presumptions, with all the pretenses. The Constitution with a capital letter, the Constitution which proclaims to be supreme. In contrast to the actual Constitution, which might deviate and which might also deviate considerably from what is contained in the written phrases of the Constitution. That is the actual small letter Constitution with no pretenses, but that's the actual Constitution. That is what the Constitution really consists of. That, in a sense, is the crux of the matter.
And is that unique to South Africa, or is this a worldwide norm, that the Constitution is never supreme?
Yeah, I think it's a worldwide norm. At the moment, or let's not say norm, a worldwide phenomenon. The basic point of departure of present constitutionalism is that you can, in a sense, disrupt politics, that you can, in a sense, steer politics by simply adopting a constitution, by calling it supreme, by describing it possibly as the best constitution in the world. In other words, by actually having a kind of a constitutional theology, in terms of which you provide it with a number of pretenses, in terms of which it appears, it poses to be the actual force within a constitutional order. But that is actually not happening. It's not happening in South Africa. It's not happening in the United States, Germany, no place in the world. What might happen, yes, is that the actual events, the actual way in which politics might be unfolding within a particular state, might be very close to the phrases of the Constitution, as you might, for example, have in Germany or in the Netherlands also. And that might create the impression that the Constitution, the written document, the one with the capital letter, that is the actual real supreme force. But the actual supreme force in the final analysis remains what is actually happening within politics. You might have a situation in the two jurisdictions that I've mentioned, say Germany or the Netherlands or England, that those events are in close conformity with the written phrases of the Constitution. But that is not to say that those phrases are supreme. It's still the unfolding reality of politics that remains supreme. In South Africa, however, one sees it clearly every day, precisely because the actual events unfolding in politics, taking place with velocity, high velocity in South Africa, that clearly demonstrates to one that here you have a very graphic demonstration of the Constitution's, of the fact that the Constitution is in fact not supreme, and that those events, as I've said, that they are supreme to the extent that one wants to use the phrase or the concept of supremacy.
Can you give us some examples of how the written, the so-called, the Constitution with the C clashes with the unwritten Constitution in South Africa?
Yeah, I think there are many examples. When the book was published 18 months ago or so, I mentioned 8 examples, which one can discuss 8 examples, which are all included in chapter 5 of the book. In the first instance, let me just finalize my sentence. But in a sense, the book is already dated. That's obviously not very good advertisement for the book. But the principle is still obtains, even more so than 18 months back. But the point is you can add more examples now. But let me come to an example because that's what you've asked. In the first instance, the Constitution says that the public service, the police service, and so on and so forth, should be a professional service. The highest principles of professionalism should be followed, should be adhered to. There should be no partyism, to use that word, in the sense that the ruling political party can simply appoint its own cadres, to use the typical South African current phraseology. That basically is what the Constitution says. The Constitution, in very highfalutin words, actually makes provision. One can even use the word guarantees, because that's part of the constitutional theology. Guarantees a professional public service, police service, army, and so on and so forth. Precisely the opposite holds true, because the ANC has been following the policy and a program of cadre deployment, which in itself is a consequence of the whole idea of the so-called National Democratic Revolution, which I in the book called the ideology of transformationism. So it's not just a fleeting thing. It's something which is a permanent characteristic of the constitutional order, and that has completely superseded what the Constitution seems to provide for in the in the provisions that I've mentioned concerning the professional public service. And that in itself has led to also dismantling, in a sense, and superseding a number of other constitutional provisions. For example, if you look at the constitutional provisions that relate to the police and the army and so on, specifically the police, then the Constitution provides from Section 198, 199, 200, and so on, that there's a single police service, that such police service is responsible for combating crime, for eventually prosecuting crime, together with directors of the director of public prosecutions and so on. Is it happening? No, obviously not. We have a broken police service, which simply has proven overwhelmingly to be completely incapable of dealing with the crime problem in South Africa. And in the place of that, a huge private security service has come into being, which pro rata is the fourth largest private security service in the world, after countries such as Guatemala and so on. Not very good company, isn't it? And together with that, one obviously has the phenomenon of neighborhood watches and so on and so forth. So in a sense, that those provisions have fallen by the wayside.
Sorry, if I understand you correctly, basically you're sort of making the argument that we shouldn't make the Constitution as wordy as possible, because the thicker it is, the harder it is to apply it, the so-called the written version. So there's sort of an argument you're making, keep it as simple as possible, because then it will be easy to apply it.
It's not precisely that. It's not precisely that. Let me explain it as follows. I say, on the one hand, you have the written constitution. That written constitution might appear to be a good constitution, in the sense that at least a number of the provisions, even important provisions, are the kind of provisions that you would like to have in a constitution. But that is not to say that this is what the constitution actually entails. You might have three phenomena. In the first instance, you might have the phenomenon where, as a result of political events, as a result of socio-political forces, such as the ideology of the ANC that I've referred to, simply cause those provisions to lapse into nothingness. Okay, so it falls away. I call it lapsed law. It's not something that you find in traditional constitutional doctrine, but traditional constitutional doctrine is inadequate because it doesn't cater for that phenomenon. So you have lapsed law. In the second instance, you can have a situation where you don't only have lapsed law, but simply as a result of consistent new usages, practices, you have new constitutional law coming into the place of the existing constitutional law, even without such new constitutional law being reflected in the text of the Constitution. And these examples that I've just referred to concerning the question of cadre deployment and of the security services, to my mind, are telling examples of how the Constitution has, on the one hand, simply fallen by the wayside, and not only that, but has also been replaced by new actual constitutional law, which is to be found not in the text of a constitution, even the text of legislation, but is to be found in what is actually happening within society. I might just mention a last example, which I also discuss in the book, and that is where you have a situation where you have wonderful provisions written into a constitution, but where such provisions simply never come to life in the sense that they're actually followed. In other words, you have a situation of what I call stillborn law. It's wonderful. It seems to be law. It's in the Constitution, but it never happens. And to my mind, a classical example of that is the constitutional value of non-racialism. The ANC is not committed to non-racialism, not at all. And as a result of the fact that it has for a long time, in a sense, proven to be the main force in the South African constitutional order, South African political order, non-racialism has simply from the start, right from the outset in 1996, simply fallen by the wayside. We don't have non-racialism, we have multiracialism, and we also have a multiracialism which is very, very often quite nasty. So that provision has never become actual living constitutional law. So in other words, if you want to form a proper idea, if you want to get actual knowledge and insight as to what the Constitution or a constitutional actually provides for, you can begin with a written text of the Constitution. But we won't. That might be a misrepresentation. That might mislead you. In order to establish what it actually entails, well, you must look what's happening around you. In what have we seen last month in KZN from around about the 9th till the 16th, 17th of July? We've witnessed a completely broken police service, a completely broken army, and so on. And to the extent that people's interests, life, limb, property, and so on, had to be looked after, it was up to the various communities themselves to look after that. What is that? Is that only a political fact? Well, it is a very important political fact. But at the same time, it's a crucial constitutional fact because it explains to you, it demonstrates to you that what the Constitution has to say in regard to the question of protection, namely of the state's so-called monopolized authority to look after our interests, that is simply not true anymore. If those interests have to be looked after, that's up to the various organized communities. That is a new constitutional fact. It has been demonstrated. That's what I'm saying.
Yeah, correct me if I'm wrong, but as far as I know, the UK does not have a written constitution. Do you think, what is your opinion on that? And what are, for example, the advantages or disadvantages of having an unwritten constitution?
In the first instance, you're spot on. They don't have a written constitution, at least not a written constitution contained in a single document. I'm very fond of English constitutional history. In a sense, the English Constitution is contained in a large number of documents that have been adopted through the ages, going back to, difficult to say, going back to the 13th, 14th century, a lot of activity back in the 17th century and also after that. So it's a large number of documents and a large number of practices, conventions, and so on. But the main thing is that by and large, a particular consensus has developed as to what is the best way to govern English society. Okay, so there's a cultural consensus, and that cultural consensus constitutes the English Constitution. Now, if you have a consensus in society as to where power should be vested, as to how power should be exercised, which are the very typical constitutional questions, then you have a well-functioning constitution. Because in that case, you don't even refer to rules because you know almost offhand exactly what to do.
That's interesting.
Because it's part of the cultural consensus. If you don't have a consensus, and this is precisely what is obtaining in South Africa, you have the Constitution with the capital C on the one hand, but clearly there's no consensus as to what should actually be happening. Even the ANC, mainly the ANC, differs largely with what the Constitution says. They have their own views on precisely what should be happening. There should be a so-called transformative society in which they should be the authoritarian, even more than that, the totalitarian force, and everything should be in step with that. They should take over all so-called levers of power in society. So what do you have? You have a fundamental break between the written constitution and the doctrines of the ANC, and those doctrines have simply caused the Constitution to be increasingly falling by the wayside. And just to come back to your question, demonstrating that consensus that you have should be having in society, which is on the one hand the infrastructure, but at the same time also the very gist and the very content of the Constitution is simply not there. So precisely for that reason, we are in a consistent flux in the sense that the constitution, that the actual constitution is created and recreated and once again recreated as we go along.
That's fascinating. So, unwritten constitution in that sense is better because it demonstrates consensus if the society operates. But I mean, isn't that unique to the UK because the UK has such a long experience of law going back to the Magna Carta? And for example, if you just got rid of the Constitution of South Africa tomorrow, I think it would make the situation a bit worse, right? I don't think.
Yeah.
What is your opinion on that?
No. You see, if I may just refer to the book once again, in chapter 1 of the book, which is quite a theoretical chapter, I deal with the question of what is the gist of constitutionalism. And now, let me not go into all the details of that. Obviously, we have 1 hour, we don't have 12 hours. But one of the aspects of constitutionalism is that there should be rule of law. But what is the basis of rule of law? Rule of law is not in the first instance based on enforceable rules, mandatory rules that we are actually aware of. More correctly, it would be to say that there are certain unwritten practices that all of us follow because by and large, we belong to the same culture, we adhere to the same traditions, we think as a result of the way in which we have been brought up and so on and so forth, that there's a certain way in which things are being done. There's a constitution, as the two of us are speaking here. You speak with me in a certain way, I speak with you in a certain way. There's no problems. Why not? Because we share a particular culture as to the constitution of this conversation. This is also how a proper society functions. So you don't think so much of legal rules, culture, moral rules, even religion, and so on and so forth, rules of feasibility, that actually determine how the constitution should be functioning. And in the absence of that, where you simply have to fall back on written rules as the first and the final strategy in order to sustain a constitution, well, that's simply not enough. In the absence of a common culture, in the absence of the common culture, which is the backbone of the consensus as to how a society should be governed, you can't have a constitution. Then you have a bellum omnia contra omnes, a war of everybody against everybody, as Thomas Hobbes has said, which in a sense is what we, to a certain extent at least, have in South Africa. Back to your question. An unwritten constitution, a functioning unwritten constitution, is not going to work in each and every society, okay? Precisely because you have a lack of such consensus. But if you have a non-written constitution functioning within a society, and if it functions well, that's actually an excellent testimonial of a well-functioning society in which such consensus obtains, and at the same time, you then also have a well-functioning constitutional order.
And that's very interesting. But so a constitution is essentially an artificial construct, and if we abandon it, what will follow will be organic. We will be applying laws that, for example, like you just said, there's no constitution commanding the Zoom call. But we're getting along fine. There doesn't have to be a constitution.
Yeah.
But it's interesting that sort of if you abandon the constitution, South Africa might split into various factions, but that would be what is required. It was the constitution that was holding us back.
Yeah. You know what? You're raising a very interesting point. At the moment in South Africa, we're dealing with broken families, and so on and so forth. We're dealing with a lot of crime. We're dealing with warlordism increasingly. We're dealing with warlordism. We're dealing with warlordism within the African National Congress. They are fighting it out with bloody means as to who should be candidates. There's a long history of that being recorded, of how many murders have been committed within the bounds of the ANC. So say, for example, today, you remove the constitution. what will happen in principle is one of two things. In the first instance, you will have warlordism just taking root. Not only that, that you will have in communities, and I use community in contrast to society broadly, samenlewing. But within the broad society, you have communities which might be well functioning. The suburb where I live, there's no crime. If there is crime, crime comes from outside. But within the suburb, there's no crime at all. Okay, everything is actually functioning well. So, and so you can mention many examples in suburbs, in cities, in towns, in rural areas, and so on, where you have such consensuses existing. So when you remove the constitution, you won't have the problem of warlordism. No, you'll have something, and that's a concept that I haven't introduced in the book. I want to write on this because I think it's fascinating. It's the concept of default law. Default law. Okay? So you remove law completely. Does that mean you remove criminal law, which says you're not allowed to murder somebody else or to assault or to steal and so on and so forth? If you remove that, say all of that is contained in legislation. If you remove that, does that necessarily mean that you will fall into a state of chaos and anarchy? Not necessarily, because precisely as a result of the community consensus, which is existing in many communities, there will be that default law, that culture, that cultural consensus, which actually forms the backbone of the law that comes into the place of the legislative instruments, including the Constitution as a written instrument that has fallen by the wayside. So in other words, you're not necessarily going to fall back in a situation of everybody kills everybody. No, you'll have a situation of default law and substituting constitutions anchored in communal consensus, which become the new and actually formal constitution in those cases, in that scenario.
I think you've mentioned a few times now that the South African Constitution is quite highly regarded in the world. It's a common cliche that South Africa is one of the best constitutions in the world. Do you think that is the case? I believe it was Ruth Bader Ginsburg was one of the judges that said South Africa has a great constitution, especially because of the socio-economic rights. Do you think it's a good thing to have socio-economic rights in the constitution?
Okay, you're asking two questions. The one relates to is it the best constitution, really such a good constitution, and the second one about socio-economic rights. Both call for proper answers. In the first instance, how do you establish whether a constitution is good, more specifically, whether it's the best in the world? What's your criteria? Obviously, when you make such a statement, and I deal with undergraduate students with this specific question. By the way, you could have sold this to undergraduate students 10 years ago, the best constitution in the world. You can't do it anymore. I speak from experience because it's not in keeping with youngsters and older people's experience. So how do you determine it? What's your criteria? In the first instance, are you going only to look at the writing, the written instrument, or are you going to look at at what is actually happening? Now, I'm saying that if you deal with actual way people are living in terms of whatever, then most certainly you're not only going to stick to the written instrument, because that might tell you nothing about what is actually happening. So the written instrument itself might prove to be completely inappropriate as a criterion. So you can't use that. In the second instance, has any research been done in which all constitutions in the world have been compared with each other, in which case you could possibly come up with such an extraordinary statement that this or that constitution is the best in the world? That's the second part. No such research has been done. So it's a completely meaningless statement to make. And then just lastly, where is the Constitution? And that brings us back to the very first question that you've asked and my very first answer. Where is the Constitution? What is the actual Constitution? Is it this one with a capital C, with all its pretenses, which pretend to be the actual Constitution? No. In this dynamic situation, tumultuous situation very often, that that you have in South Africa, the Constitution is contained in a huge number of other things. Very many things have, as I've explained, and I can mention many other examples, simply fallen by the wayside. So in other words, the thing that you want to compare with some other things, you don't know what that thing is. And obviously, if you want to make a comparison, you have to have at least two entities to compare with each other. If you don't know what the one entity entails, well, then the comparative exercise cannot follow. So it can't follow. It's a completely meaningless statement to make. That's my answer to the first question. As to the second question, I am not attracted to the idea of socioeconomic rights at all, which is not to say that I don't have feeling for poor people, jobless people, and so on and so forth. But there are very many ways in which that is to be dealt with. My basic argument against the idea of socioeconomic rights is the following. Socioeconomic rights in the Constitution, which you have in South Africa, Section 26, 27, and so on and so forth, pretend to be very empowering. They pretend to empower, as we like to say in South Africa, the people, then the public, to use a more appropriate word, and especially poor people, people in need, and so on and so forth. Does it really empower people? If government has stolen something like 1 trillion rand, according to the president himself, speaking 2 years back in England at the conference, has stolen so much money. If you have such a broken public service where the Department of Social Development, a very inappropriate name, social development, with the Department of Social Development is a broken instrument that cannot properly administer itself. If you have an extremely bad economic policy which is being followed in South Africa for a variety of reasons, well, then eventually you run into tremendous budgetary problems, which is the present situation in South Africa. So what happens to socioeconomic rights? Well, nothing. Those rights, so-called rights, lapse into wishes, not rights. You can't enforce them. So the final analysis, do such rights in fact empower people? Precisely the opposite holds true. They disempower people. So that is the fundamental reason, and we can go into some detail. In the previous book, Politiocracy, I wrote in that, if I remember correctly, it was in chapter 6, 7. No, I'm not attracted to that at all, amongst others for the reasons that I've just mentioned.
Yeah, I can definitely, I couldn't agree more. I mean, one right I find particularly annoying in the Constitution is, I believe it's Section 10, the right to human dignity. It's such a vague, I mean, judges use that right to justify anything. And yeah, I mean, but I believe before we had a conversation before we started this interview, and you mentioned that we will soon see the arrival of micro republics, if I'm saying that word correctly. What do you believe? What do you think will be the characteristics of a micro republic? Will it have constitutions? Will it not have constitutions? How will these micro republics arise in South Africa?
Okay, just in passing, as far as the question of dignity is concerned, I agree with you. It's a different conversation, but I fully agree with you. I think the whole thing of dignity is very important. Okay, but to use it in litigation, I mean that's really a total non-starter.
It's like saying everyone should be happy, or everyone should. It's pointless. But yeah, sorry. Continue.
Yeah, pointless. I think the basic grounds of this answer is the following: a constitution is not written; a constitution is built. It develops through action. So at the moment in South Africa, I think there are already a wide variety of micro republics being built under construction, so to say. So they might not have constitutions. There might be certain documents already at play, indicating how such micro republics, and I tease out the exact meaning of that just now, hopefully, how they should be functioning. They don't call themselves micro republics as yet, but they are that in the process of being made. In the first instance, you have what one might call an enclave, a community of people living living in a particular spot. It might be a security town, security village. It might be Orania. It might be the Southern Cape, Mossel Bay and George, for example. Or it might be places in the West Coast, and many other places too. In those, they are already to a certain extent enclaves, not with hard boundaries, but still there are boundaries. There are boundaries. They are policed, not by the police, but they are policed by private security, and they are policed by neighborhood watches and so on. So that is already a fairly advanced form of state formation, or what I can then call republic formation, in the sense that you're actually usurping, to use a very hard word, or let's leave that aside for a moment, you do utilize fairly hard power, because you're dealing with the question of safety and security. Apart from that, many other things are already taken care for, such as schools, which might be public schools, but many communities pay much more money in order to appoint more teachers, have a look at the sports grounds, and so on and so forth. And then obviously there are also private schools and all the other private educational institutions, which boils down to the fact that that particular function is already in part being taken over. If one looks at social security, not in the sense of social rights, but social security, particular communities reaching out to people that have developed economic and social crises, for example, as a result of the COVID scenario. And so I can continue by saying that in many of these, in many enclaves, such as those that I've mentioned, and we can expand the examples, you already have certain form of autonomous exercising of power within a particular area. So in other words, the nucleus of, so you have enclaves, but the nucleus also of state formation is already there, in the sense that certain functions that one would usually associate with state functions, governmental functions, are already taken over and exercised, most probably in a more effective way than at least the South African government would be exercising those functions. And I think in that way, you have a situation of micro-republics, micro in the sense that they are small, they are limited in terms of population and in area, but they are increasing and increasingly stronger in terms of the exercising of functions, responsibilities, including harder and harder responsibilities, which you more and more associate with state functions. They are then in fact developing and are in the process of being developing into micro-republics. It's happening in front of us. We're actually witnessing it. But as a result of the fact that we don't use political, more specifically constitutional terms in order to describe it, it might escape our attention that this is in fact happening. In South Africa, as far as this is concerned, the sky's the limit. Why? Well, because you have a retreating state, you have increasingly a failing state. But a failing state does not mean that you have a failing society. On the contrary, you might have within that society, within the populace of the state, you might have a wide variety of localized communities, cultural communities, and so on, which are simply filling the void left by the retreating, by the failing state. And this is precisely where you have the situation of the development of, the fledging of new political entities, which to my mind should be called micro-republics. Just lastly on this point, which is not to say that they claim to be sovereign. Okay, that's a legal term, specifically a constitutional term, which very often is also so devoid of content that you can actually not work with it. You can't deal with it. The crux of the matter is which functions are exercised by whom. And if those functions within a specific area, within a particular community, are being exercised not by government, but with those informal governments and increasingly also not so informal anymore, by them, then you have not enclaves anymore, but developing republics.
Just for interest's sake, why do you specifically refer to a republic and not an enclave? Why specifically the word republic?
Okay, that's I think a good question. I should have dealt with that. It goes back to Latin and to the Roman tradition. Res publica, the thing of the public, the common asset of the public. So if you have such an enclave with a number of common interest in terms of the populace, the people living there, in terms of their institutions, their schools, their security services, their own provision of water and electricity, their own provision of roads, water safety, and so I can continue. What do you have? You have arrays, things, assets in common of the public living there. And they are governed, they are administered by the institutions assigned to by the public living in that particular fledgling republic, fledgling enclave to that end. And that falls in a full-fledged way within the definition of what one would normally call a res publica, a republic.
Okay. If I can pivot, we recently saw a referendum, a poll result that the majority of the people in the Western Cape now want a referendum on Cape independence. And Phil Craig, the leader of the Cape Independence Advocacy Group, has now announced that he will summon or constitute a constitutional, I don't know precisely the term, but they want to now write a constitution for this future Cape of Good Hope. What advice would you give Phil Craig and the people that want to create a future Cape of Good Hope in terms of what should be in the Constitution, what should not be in the Constitution? Or should there be a Constitution?
Yeah. In a sense, okay, the Cape province already does have its own constitution, which it wrote back 20 years ago. So it already has a constitution. That is not what we're dealing with here. What we're actually dealing with here is that the Cape has, in the past 20 years, become a complete different political and constitutional animal than the rest of South Africa. It's functioning well. Its population looks different, and it is different in a variety of spheres. For example, you don't have in the Western Cape, at least in the Western Cape schools, this kind of animosity, for example, against Afrikaans schools, which you find in Gauteng, precisely because of the government which is in power there. So in other words, over and above the actual written constitution of the Western Cape, you have, as a result of the practices that have been in place there, already a different fledgling constitution in the way that I'm speaking about it. So that's already in place. And I think precisely that, and that precisely also then the difference between the Western Cape and the rest of South Africa has caused people to want to actually formalize that. And you formalize it in a way in that you start to attend to the possibility of writing a constitution, and that is where they are now. Stop me if I'm veering from the point. Such constitution might not be that they are about to write, might not be formal in the sense that it is tomorrow or the day after that going to receive a formal stamp from Parliament. And it might not be precisely in keeping with the constitutional requirements set out in the 1996 Constitution of what a constitution must comply with. On the contrary, there might be problems. There might be restrictions. The central government might, or national government, as it's formally called, might want to disrupt that whole process. That's not to say that they will be successful in that. What is happening in this case? They call it the constitution that they want to write, which is a good idea. But strictly speaking, it is a political exercise. Why?
Yeah.
Because it engenders an extreme amount of political energy. It demonstrates to people, look, over and above this cul-de-sac, this political cul-de-sac that we've ended up in South Africa, there are other options which are very attractive, especially if compared to what you have in South Africa. In the rest of South Africa.
It's probably also just to accentuate the difference between the Western Cape and the rest of South Africa. You just claim to earn the difference.
Yes, that is so. Okay, your question. I think the very important thing is that they must strive towards getting as much as possible powers for the eventual Western Cape government. And then the second point, I would also emphasize the aim specifically of getting hard power in the sense of police power. That's very important precisely because there's a need for that in view of the failure of the South African government in the rest of the country actually to cater for that. And then lastly, I think the emphasis must be placed on tolerance for the variety of communities. There's a variety of communities in South Africa. You make the Western Cape entirely different from, for example, Gauteng, where you have, as a result of NDR transformationism, this intolerance towards a variety of communities, the intolerance towards cultural communities and so on. So I think the Western Cape should actually be the diametrical opposite of that, and that should also be reflected in the constitution about to be written. And just lastly, even though such constitution might not enter into force tomorrow, it's a very important political motivation. And I think from that point of view, it is a sensible thing to do.
Would a canton system like they have in Switzerland be an ideal mechanism for the Western Cape because we are so diverse? That let every race group determine its own fate in the Western Cape?
Yes, I think that's a very good option to consider. I would not use the word racial group. I would use the word cultural group. Not because of political correctness. I just think that's more realistic actually to say that, because you have those commonalities between people belonging to. Because a community where you have people that might be belonging to more than one racial group, but you have cultural commonalities. So the basic idea of a canton for the Western Cape, yes, I would think that is a good idea. That is at least a good and an advisable example to follow. I think one is on the right track if you consider that.
One question I definitely want to ask you as a former state prosecutor and magistrate is many South Africans can't grasp or understand how people like Shabir Shaik and Jacob Zuma managed to get sentenced to jail, but then through life ailments or supposed threatening diseases, they end up in the hospital and all of a sudden they are walking about again. Can you explain to us what's going on there and what can we do? What rules can we change, and which can also help a future Western Cape that won't allow this to happen again? That we don't have lawyers that just argue for that the president is terminally ill and now he has to leave prison.
The most important thing is that there should be fidelity to the rules that you actually adopt. And this is not the situation in South Africa. We have a constitution. We have a Criminal Procedure Act. As a prosecutor, very long ago, I dealt with the Criminal Procedure Act. It's an excellent act, no question about that. It goes back to 1977. Detailed act. You must just follow the act. That's what you must do, and you must see to it that you have officials who know in the first instance, and they do know what the Act says, what the Constitution says, what other applicable legislation say, and they must follow it. What is happening is simply that the rules are bent. That takes us back to the very first question, the very first answer, where actually all these things are taking place as a result of the fact that much of the Constitution, Criminal Procedure Act, and so on, have in many cases actually fallen by the wayside, constituting a new constitution. This is what is happening. Okay, so the main problem is not what is written in legislation or in the Constitution. The main problem is that Constitution has actually fallen by the wayside as a result of the fact that people are actually loyal towards something else, towards the ANC, towards a particular grouping within the ANC, and that is, so to say, calling the shots. That is the deciding factor. Just lastly, this is also a problem with the Constitutional Court. A colleague of mine, Dr. Helen Kerloos, for which I have great respect, we wrote about that question just in about the question of the Constitutional Court's action regarding giving Zuma the opportunity to approach the Constitutional Court for a so-called rescission, that is cancellation of the judgment that it gave in, when was it, the beginning of July. That's a farce, because you can't do that. You can do it in some circumstances. Those circumstances are not at hand. We discussed that. He's actually asking for a cancellation of the sentence, but of the judgment. But strictly speaking, it's an application for a retrial. Now, Zuma can try whatever he wants to try, but the Constitutional Court, which, by the way, is the apex court, should not allow that. They should act like a court. They should act with integrity. Now, I'm saying here, and not only on this forum, but I've said it on various forums, they're acting without integrity. They should act like a court. They should act forceful. They should use the powers that they are supposed to have. That's the reason why you have this malfunctioning of the system. Once again, they're actually cooperating in bringing down their own integrity and in disrupting the Constitution and in creating a new Constitution where you have rules for specific people in specific circumstances, which should normally not be allowed. That's the problem.
When Zuma appealed the Constitutional Court's decision to the High Court, was that the first time that has ever happened in South Africa, that a Constitutional Court's decision was appealed to a High Court, in a High Courts, excuse me?
Yeah, that it was not appealed. It was not appealed. Okay, that was an application that was brought to suspend the warrant of arrest. It was basically that. Now that was a clear mistake that Dali Mpofu has made. He approached the wrong institution, the wrong forum. But also that is very odd. But that's simply as a result of the fact that the advocate in the case hasn't applied his mind to this matter. What is actually more extraordinary and outrageous is what I've just mentioned, where the Constitutional Court allows itself to be taken onto appeal. I mean, it's ridiculous. Well, they acted ridiculously. I should just lastly mention, concerning this question that you've asked. We have a disruption of the criminal law system, not only with regard to Zuma, not only with regard to senior figures with the ANC. Yes, many figures of the ANC should in fact be behind bars. People who have committed crimes, but they're never prosecuted. Why not? The reason why they're never prosecuted, there are many reasons, but one of the most important reasons is this: that the ability of the prosecutorial services has been scaled down, has been disrupted, has been destroyed almost, as a result of which the current prosecutorial services is nothing more than a very vague shadow of what they used to be 25, 30 years back. That's the reason. In order to prosecute, you must have policemen who can attend to the specific docket that is his responsibility or her responsibility. Person must be able to have colleagues that he can ask for help and so on. He must be able to attend to the case, and then he must take the case to the prosecutor, and the prosecutor must be available. The prosecutor must be au fait with the law which is at stake in that particular case and institute the prosecution. Well, they're not there anymore. That's the problem. It has been hollowed out completely. This is what you have. So on the one hand, you have this tremendous criminality and it's criminality within the ANC. And on the other hand, you have this broken prosecutorial and police services, which together constitute an increasing situation of a criminalized state. And what is interesting to me in political commentary is people are increasingly quite candid and quite open to describe South Africa in particular, specifically that in that way.
Yeah,
and there's a good reason for that. And amongst others, that is in fact a reliable description of what has been of what has happened. In other words, it was a constitutional change that has taken place, a huge one. This is what we're having here.
Do you think a Truth and Reconciliation Commission would have solved all of this? I recently saw a video on CakeNet where I believe it was an advocate that argued that there was a problem with corruption in Hong Kong, and they instituted a Truth and Reconciliation Commission there to solve the problem of corruption within the police force. And within, I believe, a few years, that problem was solved because the smaller fishes reveal the bigger fishes, right? They wanted, if they admitted to their crimes, they were prosecuted, and the bigger fishes they went after the bigger fishes. Do you think a Truth and Reconciliation Commission would have solved South Africa's problems?
No. However, I should add the following: that the Zondo Commission has been proving to be an extremely successful exercise. What is the criterion? One could possibly use as a criterion that the question of how many prosecutions are going to follow. If you say, well, we have to measure the success or otherwise of the Zondo Commission against the number of prosecutions that will be followed, it won't be successful because the prosecutions won't follow. It will follow only in some cases. But it has proven to be extremely successful in the sense that a huge number of evidence of people testified, that the investigations that were done by the staff of the Zondo Commission was, I think, by and large good. I know some of the people there, they are very competent people, and the evidence leaders were good. There's no question about that. Good evidence leaders. So what has happened is, this is my criterion for the success, for the Commission's success. It has cast light day in and day out on the actual nature of the South African state under the ANC. This is precisely why we could be in agreement now that South Africa is increasingly a criminal state. It's amongst others thanks to the Zondo Commission, but then we must go one step back. That on its part is also thanks to the excellent work of political parties, more so of NGOs, and on the same level also of investigative journalism and so on, which has eventually forced the hand of government to appoint a commission such as the Zondo Commission. So in a sense, the Zondo Commission has been proven to be precisely that Truth and Reconciliation Commission, casting light at what has been happening. Okay, will it serve to stamp out corruption? No. Why not? Because the ANC's policies, that's a very important thing. The ANC, we're dealing with the question of state capture as if it is some kind of aberration of a policy, some kind of aberration committed by some people. That is not what we have in South Africa. The ANC's policies are, by definition, one of state capture. They say so in their policy documents. They say we, as a party, want to obtain, we want to have control over each lever of power in South African society, including the civil service, including the legislature, the executive, the courts. They say so directly, and that's actually what they're doing. We see malfunctioning of the Judicial Service Commission. This week, isn't it? They're going to go for a re-go through the interviews that they did in April. It's malfunctioning. It's the Judicial Service Commission. Who's the chair of the Judicial Service Commission? It's Mogoeng. Who is Mogoeng? Well, he's the Chief Justice. He's a malfunctioning. And
they also just recently took action against, I believe it's Judge Shope. Yeah, only recently. I mean, You should have been taken care of years ago.
Precisely. Why was it so? It's precisely because of the Judicial Service Commission themselves. I've been following that saga through 13 years. Okay, so we can continue. But let's wrap up. The reason why a Truth and Reconciliation Commission won't work is because the ANC, through their policies, is committed to state capture and to society capture, which by the definition is most probably the most severe form of corruption that you can conceive of. That's the reason.
Well, that's fascinating. So there's no real point in a Truth and Reconciliation Commission because the corruption will only return. I mean, the problem is systemic. It's the policies. And if you don't get rid of the policies, it's just gonna. You shouldn't have the idea of how do we solve the problems. You should think about how do you prevent those problems from rising ever again. But but Professor, this has been a fascinating conversation. Thank you so much for your time. I don't want to take any more of your valuable time. I want to give you one last opportunity to add, plug, or say anything that you want to.
Thank you. Thank you for having me. It was excellent speaking with you. Thank you for the questions, which were very relevant and very intrusive questions. I appreciate that. And as a last word, I would say, well, look, possibly we have concluded in a very pessimistic way by saying, well, there's no way in which something can be done about this situation of corruption through a Truth and Reconciliation Commission. The fact of the matter, however, is that on the one hand, the ANC pursues these policies of taking over all leverages of power. At the same time, they try to do so with a broken state. And precisely that means that the state actually eventually, in front of our eyes, is breaking down, precisely creating the opportunity for all these enclaves that we've referred to, which is fledgling in South Africa. It's wonderful. It's captivatingly interested, and it is fascinating, and it's creating a tremendous amount of opportunities. And one should not allow constitutional formulations to stand in the way of that, because they are not standing in the way of that. We are in the process of actually recreating, communities are recreating South African society through this micro-republicanism that is presently in a process of developing. That, I think, is, in the final analysis, well-functioning communities' answer to the broken South African state. Let's not try to solve, to address the problem of the entire state. We can't solve that, but most certainly we can create. We can attend to our communities, to our various communities, and create forms of increasing micro-republicanism, increasing autonomy for a large variety of communities, which also take hands with one another. In that way, South Africa could, in 5-10 years from now on, be a fascinating place, at least for the people who decide, let's actually turn our attention away from the broken state and attend to do some things that we can, in fact, meaningfully attend to, and that is creating and developing the autonomy that we could possibly have within those fledgling micro-republics. I think that's our answer.
Now, a relevant quote here might be, it's always darkest before the dawn. And the new dawn, or the real dawn, not the new dawn, that we might see in South Africa will be very interesting. But thank you so much, Professor. Thank you so much for your time. If you've made it this far, please consider liking this video, sharing it as widely as possible, and subscribing to our YouTube channel. My name is Donald, and this has been WorldView.